right, folks, it's now time to call this meeting to order. Would you please stand and join me for the Pledge of Allegiance? Allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Amen. All right, Denise, will you call roll, please?
Certainly. Good afternoon, everyone. Chairman Clark.
Aye. Here.
Vice Chair Smith.
Here.
Board Member Bonagofsky.
Here.
Board Member Willett.
Here.
Board Member Maleko.
Here.
Board Member Tony.
Here.
Okay.
Board Member Kratz.
So that's everybody? All right. Well, since it's been since October since we had a meeting, I'm now looking for the approval for the meeting minutes for October 3rd of 2023. But first of all, do we have any questions, any corrections or anything regarding those meeting minutes? No questions? No corrections? Okay. Well, then I need a motion and a second. Got your mic on, Bob?
No, I don't. Thank you for reminding me. Mr. Chairman, I move that we approve the minutes of October 23rd, 2023 regular meeting of the Board of Adjustment.
I have a motion. Do I have a second?
I'll second that.
Okay, I have a motion and a second. Denise, will you call roll?
Certainly. Board Member Willett.
Aye.
Board Member Bonagofsky.
Aye.
Chairman Clark.
Aye.
Vice Chair Smith.
Aye.
Board Member Maleko.
I'll abstain, I wasn't here yet. Correct?
Well,
The
you
minutes should have
can
been in
still
your
approve the
Oh,
minutes.
Okay.
sure. Then I approve.
Okay.
Okay. Now, we have a couple of discussion items, and we'll start off with Patrick. Patrick, would you please give your presentation?
Certainly. Mr. Chairman, members of the board, I'm very pleased to announce that for the first time since 2020, we now have a full roster of members and alternate members for the Board of Adjustment. This has been a long time in coming, and hopefully as a result of this, we are not going to struggle to get quorums when we need to meet to consider items. So I am very pleased to make that announcement. Now, because we do have some new members, I thought it would be a good idea to start off the new year with some training. For returning members is going to be a bit of a refresher course, but for those of you who are new to the Board of Adjustment, kind of wanted to walk you through what it is that the Board of Adjustment is here for, what you are going to be seeing when it comes to items coming before you all for public hearing, and talk a little bit about public hearings as well. Corey will have more on this, our city attorney, in his presentation, which will follow mine. But anyway, let's go ahead and move along with the agenda. Title 17 is where we will find variance, and although there are other kinds of variances that the board will consider, including variances under the building code, my area of expertise and my area of responsibility is specifically Title 17, which is the zoning code. To the extent that you get any requests regarding variances under the building code, Kathy Olsher, our building official, will be the one who meets with you and discusses with you the particulars of the variance request and the relevant factors that you need to consider for that. And those are so rare that I think in the 20 years she's been here, there's only ever been one building variance request. So anyway, this presentation, as I said, is going to deal specifically with variances under zoning. So, what is a variance and why are they part of Title 17, which we also refer to as Canyon City Zoning Subdivision and Development Regulations, sometimes referred to as the Unified Development Code, or just abbreviated UDC. To begin with, let's talk a little bit about zoning. When a property is zoned, either at the time it is annexed or following an application to rezone the property, the zoning that's applied to the property establishes the specific rules. such as height, bulk, use, and any included design requirements that are associated with that particular zone district. On the other hand, further into the land development process, subdivision and site plan requirements become relevant factors in the development of a property. These not only confirm that the property will conform to the height, bulk, and use limits of the existing zoning, but they also incorporate some specific development standards, such as use, for the use such as fencing and screening, parking, landscaping, lighting, roadway access, and driveways, and stormwater management. Now, a variance occurs when there's a conflict that exists between zoning of the parcel and a specific subdivision or site plan development standard that the use must comply with. This type of conflict typically has to rise to the level that a strict compliance with the requirements of either the zoning or the development standards would effectively make the property essentially undevelopable. Now, the American Planning Association, which is the professional organization that guides the municipal planning profession, defines a variance as a request to depart from the literal requirements of a zoning ordinance or title. This departure can include relief from setback minimums or maximums, building height limits, parking requirements, landscape requirements, or some other specific performance requirement that's triggered when both zoning and the development standards for a particular use are under review for a proposal on the property. The operative word when considering variances is a hardship. Indeed, in layman's terms, you can think of a hardship as the hardship aspect as the acid test to ascertain if a variance condition even exists on the site. And it should be noted that if an applicant or property claims the reason they cannot comply with the performance requirement is that it costs too much, then their claim fails to meet the acid test hardship conditions because they cannot be measured in financial terms. Some of the more common items that can qualify as presenting a hardship include undersized lots, especially if they are legal nonconforming in their area under zoning, lots which have unusual shapes or topography, lots which contain significant historic structures or features which are considered culturally significant and worthy of preservation, and lots with protected wildlife habitat areas upon them or possessing unique vegetation on site. It is these kinds of factors that exist on a property which can create a constraint to the development of a property that would otherwise be allowed or required under which zoning would form a hardship condition. Now, there is a caution to be remembered about variances. They can, when granted, create a precedent. City attorney has told me before that he thinks I worry too much about the precedent aspect of this, but nevertheless, I have to be aware of this because if you grant a variance and a specific condition is found to exist on a property that's zoned similarly to one you've granted a variance on before, an attempt to develop the property for such and such use then creates a similar hardship. And that precedent will also allow other lots with the same conditions to have that variance. So yeah, I do think about it. Maybe it's not as big a deal as I'm making it out to be. I'm sure Corey will address this when he speaks, but that is something I think about when I analyze and report on variances for the Board of Adjustment. Now, all variance requests are considered quasi-judicial in nature, and at least in Canyon City, under our Unified Development Code, they fall into the purview of the Board of Adjustment to consider. This consideration forms the basis of a public hearing on the matter, and the first thing to know about public hearings is that proper notice has to occur. In this case, the proper notice is described in section 1710.020B of the Uniform Development Code. In the case of variances, proper notice will specify that a published notice must be placed on the city's website, specifically on the page of the website that was created for the purpose of hosting public hearing notices. If the board is interested, at the conclusion of this presentation, I can walk you through where this page can be found on the city's website. Now, the second requirement is a mailed notice, and these are sent to property owners whose land is immediately adjacent to the parcel that's seeking variance relief under zoning. Both the published notice and the mailed notice must be accomplished at least 15 calendar days before the scheduled public hearing in order to meet notice requirements. Now, why is the accomplishing of the public notice so important? Because it is jurisdictional to a local government's ability to act on any kind of quasi-judicial matter under the Unified Development Code. If the public has not been given adequate notice of the requested variance and the date and time of the public hearing, then a flaw exists in the noticing, and the city cannot conduct the public hearing until the defect is fixed. So let's say that we have a potential applicant for a variance, and it has been found to meet the hardship test for variances, and a notice of the public hearing has been properly made. The public hearing is now before the Board of Adjustment. So what can be considered appropriate factors for the board to evaluate and what should be considered out of bounds as an evaluative factor? Let's start with the items that are appropriate for consideration. Variances come with a set of criteria defined in the Unified Development Code, Section 1710-050B. These criteria include, number one, that the strict application of the UDC would result in exceptional practical difficulty or undue hardship unique to the applicant's property and inconsistent with the objectives of the Unified Development Code. Two, that there are either unique or unusual circumstances or conditions applicable to the site of the variance, such as unusual lot size or shape, topography, or other physical conditions peculiar to the affected property that do not exist throughout the neighborhood or district in which the property is located, or there is a physical disability affecting an owner of the property or any member of the family of an owner who resides on the property, which impairs the ability of the disabled person to utilize or access the property. Number three, that the unique or unusual circumstance or conditions of the property will not allow a reasonable use of the property comparable with other properties in the general neighborhood of the site in the absence of relief. Four, that the variance is to be granted is the minimum variance needed to allow for a reasonable use of the land, buildings or structures involved. Five, that the variance, if granted, will not alter the essential character of the neighborhood or district in which the property is located, nor substantially or permanently impair the appropriate use of the development of an adjacent property. And six, that the granting of the variance will not constitute a grant of special privilege inconsistent with the limitations on other properties classified in the same district. Now, these 6 criteria will be analyzed in the body of any staff report that's submitted on a variance request when it is presented to the Board of Adjustment as part of a public hearing. Another relevant item in the consideration of a variance is the advice of applicable regulatory documents. This can include, in and of itself, the Unified Development Code, as well as the city's comprehensive plan, and to the extent that such a plan has been created, a specific area plan or overlay zoning for context. So, for example, we now have a master plan for Clock Tower Plaza. In the areas immediately around Clock Tower Plaza, that should inform variance requests should someone come forward for something like that, for use either on Main Street or on 3rd Street in that area. That, you know, their variance can't detract from what we're trying to do with Clock Tower Plaza, for example. The Board of Adjustment can also consider the testimony that's offered by members of the public at the public hearing, whether they are in favor of or in opposition to the variance request. The board can also consider the quality of the proposal in terms of how well or not it answers the questions about the variance request and depicts the hardship conditions that exist on site. Of particular interest at a public hearing is context. How does the proposed variance fit with the known background of surrounding land uses, lot configurations, buildings, and other neighborhood factors? Another factor, the impact of the variance upon the neighborhood, can also be considered. What would be the logical consequence if the variance is granted? What would be the logical consequence of not granting the variance? And finally, notice. Has the public been provided with the opportunity, with the appropriate code-defined amount of time to be advised of the variance request, review it, and come to the public hearing to speak about it? So those are all the items that it is fair to consider as part of a public hearing. Now, let's talk about what it is not fair to consider. These items include the cost borne by an applicant or speaker during the public hearing to prepare a presentation. Whether someone speaking in favor or against a variance request, the slickness of the presentation is not the relevant factor. The substance of the presentation is what's relevant. Claims of a sovereign citizen argument. Occasionally, a speaker at a public hearing will come before the city and make the claim that they are not actually subject to the city's zoning code, and they may do whatever they want with their property. This is not true, and courts have debunked this logic that a property owner can be an autonomous government of one for many years now. Similar to the cost of a presentation, the time invested in a presentation is also not relevant. Whether someone spent 10 minutes on their presentation before the Board of Adjustment or 10 months isn't the point. Again, it is the substance of the request itself that matters. Another factor, personal feelings or regard for the applicant, the consultant, or the individuals who get it to speak, or indeed the neighborhood where the request is situated, are irrelevant. The merits of the request, not the people making the request, are the relevant points for consideration. Finally, how the specifics of a variance request make a Board of Adjustment member feel personally are also not relevant. It is okay to dislike the notion that someone seeks a particular type of relief from a zoning requirement. It is not okay to allow that dislike to color your opinion of the merits of the variance request and therefore how you vote when the request comes before you. Now, so the public hearing has been concluded. The Board of Adjustment has heard the staff report, analysis, and recommendation. The applicant has been afforded their chance to present an argument for the necessity of the variance request, and members of the public who received properly filed notice have had an opportunity to speak either in favor of or against the variance. What happens now? In short, once the public hearing is closed, the board's deliberations will begin, and those deliberations will end with a motion of some sort. Relevant to this are some things the Board of Adjustment should bear in mind during those deliberations and an eventual vote. First, when it comes to variances, the Board of Adjustment is the decision-making authority. Once the board has made its decision, there is no appeal to Planning Commission or City Council. If an applicant or a member of the public does not like the decision that the Board of Adjustment came to, their only remedy is to file a motion in court to vacate the decision. That's it. There are 4 possible outcomes for a variance request at a public hearing. The Board of Adjustment can either continue the hearing for lack of sufficient information, approve the variance request with reasonable conditions, or deny the variance request. When making a final decision on variances, it is important that the Board of Adjustment cite findings of fact in crafting a motion to affirmatively dispose of the variance request. These findings of fact will not only reference the city's jurisdiction to make final decision, they will be tailored to the decision, to the specifics of the application under review. Every staff report to the Board of Adjustment will contain findings of fact for the board to include as part of a motion. And finally, given the potential for precedent to be set in the granting of a variance request, the members of the Board of Adjustment should bear in mind that granting variances should be rare, connected with a specific hardship condition, and be unique to the use of the site under application. The board should not be looking to broadly modify the zoning or development standards citywide. If the board thinks a development standard or zoning requirement should be changed, you can forward a recommendation to the Planning Commission and City Council, but you cannot use a variance to make a de facto change to the Unified Development Code itself. Now, that would conclude my presentation. As always, I am your staff resource, so I am here to answer any questions that you may have. And then obviously, we also have Corey Hoffman with his presentation, but we can start that once I've heard any questions that you all may have. Yes, sir.
So I know that you're going to give a staff report on any variance requests, but is there a situation where you might get a variance request that you're not even going to kick up to the Board of Adjustment, or do you have to respond to all of them and forward them on with your opinion?
My role in the process for variances is to serve as a filter for what actually makes it through to the Board of Adjustment, because bear in mind, this board is the final decision-making authority. So when an applicant comes to me and says, well, do I really have to put 40 parking spaces in this particular parking lot? That's awfully expensive. I'd like to only have to put in 35, even though your code says 40. And I would have to advise them, well, that's not, what you're making is a financial argument. Complying with the code is too expensive. That's not what a variance is all about. Therefore, if you were to apply for a variance, my recommendation would likely be for denial, okay? They are still, therefore, free to apply for it. If they go in understanding they're going to be making a case for something staff has already told them they can't do and won't support. So every recommendation I bring you, I will have already screened and have a pretty good idea what my recommendation will be. I will never be presenting you with a variance request where I don't make a recommendation.
But do they all come through to us? For example, if somebody like built a 4-foot fence on top of their 6-foot fence and they got a notice of violation, so now they're upset about it, they present it to you, you know that it doesn't have a chance of succeeding, but you are going to give your recommendation and send it to us anyway.
If they apply for a variance, it will come to you. Not everyone will go forward with the motion of putting their money down on an application for variance and actually wanting to, put together a presentation and do the research and justify their argument. That's a lot of work. If they don't do that, you never see the variance and the issue dies then and there. If they do submit the application, you will get to see it.
Okay, thank you.
Well, and I should add, there's times where Patrick gets requests, but when they come in, after they read the code, or may even get a violation, after they read all of everything involved in it, then there's actually something workable they agree to without requesting one. So
Okay.
he has conversations like that, we don't see those.
Sure, thank you.
You got anything, Randy?
Hang on, I got to unmute. No, in fact, that was, I think we did have a variance there, a request for a 6-foot fence that was put up without,
An 8-foot fence, actually.
Was it 8?
yeah, it was an 8-foot fence, but it was put up without authorization. So going through the hardship and this and that, found out that it wasn't legal and they were supposed to take it down.
And they did.
So, yeah. So now, some things come before us and it's a slam dunk, and some other things, we just have to go with what is suggested based on the criteria. So I agree. We don't meet that often, but sometimes when the variances do come across to us, we have to make that decision based on the evidence sought. So.
Anybody else have it?
Patrick, I have a question for you. I'm trying to recall the language that you used, but you said that we can approve the variance request, disapprove the variance request, or approve with certain recommendations?
Reasonable conditions.
Reasonable conditions, as established by us, the board?
If I'm going to make a recommendation that a variance be approved with, X, Y, Z conditions, you are free to accept those conditions or reject them or craft your own, but you will always be presented with a recommendation as a basis, for if staff is recommending approval, subject to these, you will have a baseline for your deliberations to begin with.
Okay, so the reasonable conditions could be provided by city staff, or they could be provided by the requester?
They could be provided by the public when they come to speak. If they say, well, if you're going to grant this, can we ask for additional landscaping along our shared property line to screen this from view or something like that?
Okay.
Those are the kinds of things that you can incorporate. If it's a reasonable request, if someone on the other hand says, well, no, you need to put this underground 500 feet and it needs to have concrete lining, and, I mean, these are not reasonable kinds of conditions.
Okay. All right, thank you.
And I'm going to add to that, that's also something culminated out of our meeting. It makes me think back a couple of years ago, we had a request for a variance for a fence offset, and after we all discussed it, it turned out to be a modification of what they were requesting, but still met the need for traffic flow and vision, and that was an offset. The fence pretty much stayed where it was with the exception of a small portion of it, and we approved that one. Anybody else? Nobody? Thank you, Patrick.
Sure.
Mr. Kaufman, are you still with us?
I am.
Okay. You want to, or Hoffman, I'm sorry. It's Corey Kaufman.
That's okay. I've been
Well,
called
C.
worse.
C. Hoffman, Kaufman.
Well, I beg my pardon for mispronouncing that, but anyway, you're up, sir.
Okay. Well, good afternoon. Patrick stole a lot of my thunder, but I'm going to try to supplement some of what Patrick provided and get down into the weeds a little bit, especially on what we call you acting in your quasi-judicial capacity, since ultimately what Patrick was describing to you was what the law considers you to be acting as judges. Next slide. So I'm going to try to touch on all of the items on this slide briefly, but again, spending most of my time on what your role is and a couple of minutes on pitfalls to avoid. Next slide. Okay, so let's talk generally about what you do and what the law sort of, how it defines what you do. So Patrick, when he was talking about variance criteria, he went through all of the criteria. Well, the basis for acting in a quasi-judicial capacity is that you ultimately take a set of facts and apply them to the law, which in this case is your criteria. And so when you look at your powers and duties under the municipal code, what you do is you hear and decide appeals from a decision made by the zoning administrator. That's quasi-judicial. You are ultimately going to have some rules and regulations, and you're going to have facts, and you're going to take those facts and apply it to the law. Similarly, when you talk about variances, what Patrick went through, you are going to take whatever the facts are. Using the fence example, what is the basis for someone thinking that they should have a higher fence than the code allows? And is there, in the criteria, is there a basis for allowing it? And so in each of those functions, you are acting in a quasi-judicial capacity, and you are authorized by the code to act in that capacity. But what are you not authorized to do? Well, what this slide refers to when it says the Board of Adjustment shall not have the power to permit uses of land not otherwise allowed in Title 17, you're not allowed to provide what are known as use variances. So in other words, if I am in a residential neighborhood, zoned residential, and I buy up, a city block and say, I want to get a variance to put a Target in here. Well, you can't put a commercial use in a residentially zoned property. The BOA wouldn't have the power to allow that. And then similarly, you are a final decision-making body on the matters that are authorized by the code. And so you don't review an action or a determination by the city council. You have sort of a parallel set of powers. The city council, for example, decides rezonings, but you decide appeals from decisions made by the zoning administrator. You decide variances. So parallel powers, council is a final decision maker on things that it is authorized to do. Similarly, you are a final decision maker on matters that you are within your authority. Next slide. So with any body of the city, whether we are talking about the city council, whether we're talking about the Board of Adjustment, whether we're talking about the Urban Renewal Authority. The power of the body is the body. And what I mean by that is you as individuals have no authority outside of the power as a member of the body. You can't bind it. You can't promise a member of the community, for example, that if you apply for this variance, we'll get it done. It is the power to act is entirely within the body. And when we talk later about potential liability, this becomes increasingly important because you act at open meetings as a body, not individually. Similar, you don't have authority to spend city funds. You don't have authority to direct or supervise city staff. City staff works effectively for the city administrator and is within his chain of command. Certainly, you are to work with the city staff. If you are, the job of staff as it relates to your function is to give you the information you need to make good decisions. So if you get, for example, a staff report the week before you have a BOA meeting, and you see something that you think is missing in the staff report, or you have a question about something in the staff report, or need more information, by all means, what you should do is reach out to staff, because our job collectively is to get you the information you need to make a good decision. You will absolutely get evidence at the public hearing, as Patrick referenced. But again, if you think there is something missing, let us know, ideally before the hearing, so we can go and get what you need to assist you in getting whatever that information is into evidence and ultimately assisting you in making that final decision. To the extent that we give you legal advice, so you have in your packet a memo from my office that is confidential. It is subject to the attorney-client privilege. The only way that the attorney-client privilege can be waived is for the city council to waive it. So we, as the city attorneys, are employed, if you will, while we are the attorney for the city, we are the attorneys for the city by and through the city council. The city council is our client. And so when we provide privileged attorney-client communications, it would be the council that has to make a motion to waive the attorney-client privilege. Next slide. So this is the guts of what you do. The BOA really doesn't do anything in the legislative or administrative realm unless council asks you to. So for example, if the council was considering, let's say they wanted to give you additional duties, they were considering an ordinance to have you look at something in the land use code, or we're going to expand your authority. And they said, you know what, we want to have the BOA take a look at what we intend to do, the authority we intend to give them. In that context, you would be acting legislatively because you would be acting as an advisory body to the city council. But that's a very limited role and may never happen, frankly. Your job is to act in a quasi-judicial capacity as it relates to appeals from the zoning administrator, appeals from the building official at times, and most frequently on variances. And so Patrick spent a bunch of time on this, so I'm going to spend less time on the variance criteria and talk about the law and why it is the way it is. So when Patrick talks about the public hearings being noticed, the attributes of due process of law is notice and a public hearing and process that is appropriate to whatever the property right is at issue. And so Colorado law over time has identified that you are entitled, if you are seeking a variance or seeking other land use approval, to get notice and an opportunity to be heard in front of a final decision maker following a hearing where people both for and against have an opportunity to present. And the public hearing record is essentially gavel to gavel. So at the beginning of the public hearing, the chairman opens it. And if you think of everything at the public hearing being transcribed, you are essentially creating a record of the public hearing. The record is all of the facts, all of the testimony, all of the documents that are received at a public hearing. That's the evidence. You take that evidence and you apply it to the criteria in the code. You have your applicant, or in many cases, staff will do a presentation. The applicant will then do its presentation, and then you have any folks that may show up at the public hearing, both for and against, that present evidence. Those people are subject to cross-examination. So if you have a question for an applicant, or you have a question for someone that is speaking against an application, you absolutely have the ability to ask them questions. And then at the end of that hearing, you make a decision based on applying all of that evidence to the criteria in the code. When your decision, if your decision were to be challenged, is challenged, the judge looking at your decision does not determine whether you were right or whether you were wrong. Judicial review, when you talk at the bottom of the left side of this slide where it says subject to judicial review, Patrick, I think, mentioned it would be a motion made to seek review. That's not entirely accurate. Someone actually has to file a case, and it's what's called a case seeking 106 review. 106 is a rule of the Colorado Rules of Civil Procedure, and it is the mechanism for the Fremont County District Court to review a final decision of a quasi-judicial body. But review by the district court, again, is not whether you were right or wrong. It is whether there is evidence in the record to support your decision. So when I said that you should consider that all of this is being transcribed as you are in a hearing, well, if someone challenges your decision, in fact, a transcript is created, and it includes all of the evidence and the documents at the public hearing. The Fremont County District Court judge reviews that, again, not to determine whether he or she agrees with your decision, but only whether or not there is competent evidence in the record to support your decision. The other thing a court does is make sure that the process is fair. So when we talk about due process means you have a right to a fair and impartial hearing. So I'm going to talk about the three things that can taint process, make a hearing unfair, and create a legal issue where your decision could be overturned based on the process being unfair. The first is what's known as ex parte communications. Again, you are acting effectively as a judge. So if I were in criminal court in Fremont County, and I'm in front of a jury, and I'm the prosecutor, and I am prosecuting the case in front of the judge, and then the judge calls a recess, walks off the bench, the defendant leaves the room, but for some reason the jury's still there, and I say, hey, members of the jury, the judge isn't going to let me get this evidence in, but I thought you should know, here's why I think he did it. Well, you know darn well that that is improper. Well, that's an ex parte communication. It's a statement made off the record to the decision maker attempting to sway the decision. Well, how does that apply to you folks? Canyon City, in my experience, is a small town. And I suspect folks know that you are on the BOA. And so they may see you at Walmart, see you at City Market, and say, hey, I understand there's a variance hearing. I can't make it to the hearing, but I wanted you to know why I think you should vote against it. Well, that is an ex parte communication. It is improper, and if it were to happen, it could taint the process and ultimately invalidate a decision. The idea is you all are getting evidence outside of the record if you are approached outside of the hearing in that manner, and the applicant doesn't have any way to respond to whatever information you are getting ex parte. Now, having said that, I would suggest that it is often difficult, if not impossible, in a small community to avoid the ex parte communication. Because what do? You say, look, I can't talk to you. You need to show up next Tuesday at the hearing. And what do? They keep talking. If that were to happen, the other thing you can do is cure the ex parte communication. Because the harm to be avoided from an ex parte communication is that you have information that no one else has. If you then come to the public hearing and say, you know what, last Tuesday I was shopping at City Market and so approached me and told me X. I told him I couldn't listen to him, but he kept talking and here's what he told me. And you convey that to the entire board, well, you have cured the ex parte communication because the board's heard it, the applicants heard it, and they have a chance to respond. You hope it doesn't happen, but if it does, that one is curable. The second thing that can taint the quasi-judicial process is what's known as prejudgment. As Patrick talked about and I referred to, your job is to apply the facts to the law. Well, the example that we used to have in a training video that the city's insurer put out when we gave this same training to city councils was, and this is based on a true story, a city council person or a candidate in the city of Westminster ran on the platform, "No big boxes on my watch." Well, he won his election. And one of the first land use applications he had was for a Walmart. He had to recuse himself. He could not vote because he had already told the community that he was going to vote no. And so he could not be a fair and impartial decision maker. He had prejudged, and he told the world he had prejudged that there would be no Walmarts in his community, no big boxes. In the liquor context, and you don't do liquor, but this is just by way of example, you cannot act in Colorado on a liquor application if you have what's known as an abhorrence to alcohol. Why? Because if you have an abhorrence to alcohol, the thought is you'll vote no on every liquor license because you've prejudged that alcohol is bad. It's the same idea. And then the last thing that can taint the quasi-judicial process is what's known as conflict of interest. And conflict of interest means that you have some sort of actual or perceived bias, often based on financial or some familial benefit where you wouldn't be able to act impartially on a land use application. The examples that I would suggest are most frequent are maybe a little too obvious. The most obvious one is if you're a family member is applying for a variance, there is certainly a perception at a minimum of a conflict of interest. And if you have a conflict of interest, you disclose it and then you recuse yourself. And by recusing yourself, if you have a conflict, you cannot, not only can you not vote, you can't influence the vote. So our recommendation is always, if you have a conflict of interest, you physically recuse yourself, you physically step down from the dais, you physically leave the room so that you can't be seen as somehow influencing the decision-making process. You know, for example, making faces, thumbs up, thumbs down. You leave the room, there's no question that you're not influencing the decision. The more nuanced potential conflict of interest is Let's say someone's coming in for a variance and you live across the street. Is that automatically a conflict of interest? Absolutely not. The question is, can you act fairly and impartially? But let's say that there is a question as to whether or not that variance would increase or decrease the value of property in the area. If that were the case, it becomes a much closer call. If you live next door, you live across the street, and the effect of the variance would have an effect different upon you individually than it would on the general community. In that case, you may have a conflict of interest, in which case you would disclose it and recuse yourself. We, as your staff, cannot tell you whether or not you have a conflict. You have to make that determination. However, our recommendation is if you have any questions, disclose. Make the disclosure and say, for example, this house is a block away, but I believe I can act fairly and impartially. By making the disclosure at the public meeting, two things happen. You eliminate the secrecy of a potential conflict, and it invites a conversation. If one other member of the BOA says, no, wait a minute, I think this may increase or decrease the value of your land, and don't you see how there might be an appearance of a conflict here? Having that discussion in the public realm actually addresses the underlying issue of what would otherwise be a potentially disqualifying conflict. So we always encourage disclose. If you have the conflict, recuse. If you don't, but it appears that you could be seen as having a conflict, have the conversation. And again, while we say we can't identify for you whether we have a conflict, the criteria we use is not anything legal. It's what would I do if I read about my conduct above the fold in the Daily Record? So if I'm reading about what I just did in the Daily Record and it looks bad, it smells bad, it's probably bad. And that's the gauge we use for determining a conflict of interest. But if the BOA acts without conflicts of interest, doesn't prejudge, avoids ex parte communications, and acts fairly and impartially in applying the evidence received to the criteria, its decision is going to be upheld by the Fremont County District Court each and every time if challenged. Next slide. Open records. In Colorado, records are presumed to be open to the public. So, practically speaking, the information that you receive, with the exception of privileged communication, occasionally you might receive proprietary information, but by and large, information that you receive is subject to open records. Your emails, to the extent you may email back and forth with city staff, or even with each other if you do, and I frankly hope you don't, we'll get to that in a minute. But all of those are public records, and it is increasingly common for members of the public, sometimes members of the media, to make open records requests seeking all emails of elected officials, sometimes all emails of boards and commissions. And so be aware that if you have a city email as a member of the BOA, or a private email that gets communications from the city related to your capacity as a member of the BOA, they may be subject to inspection. Next slide. Similarly, you're subject to Colorado Open Meetings Law. And so Colorado Open Meetings Law requires notice of at least 24 hours for any meeting. And a meeting is a quorum or 3 or more members of a local public body, whichever is fewer, and that is a meeting. And so a meeting can be in person, electronically, by telephone, and specifically now by email. So this meeting right now, there's many of you in Canyon, in council chambers, but you've got two of us that are remote. It is no less of a meeting with people appearing remotely. Likewise, if Patrick sends out, for example, the packet for a meeting, when he sends that packet out to all of you, it's not a meeting if he just sends the communication out and it is received. However, the minute that you hit reply to all, it becomes a meeting, because now you are having a back and forth with 3 or more members of you when you hit reply to all, because Patrick sent the first email to all of you, and if you hit reply to all, it becomes a meeting.
And
We
if I may
Go ahead.
interrupt just a second, this is why when I send out my agenda packets to either Planning Commission or Board of Adjustment, your emails are blind copied on it. I basically send the email to myself. That helps to prevent a reply all incident that would create a meeting.
But if you do reply to all, it is no less a meeting. So beware of that. We always recommend just do not hit reply to all. In addition, if someone were to make an open records request for emails of, let's say, the BOA, and found a back and forth between you all that had 3 or more of your members on an email chain, that is an illegal meeting and in violation of the Colorado Open Meetings Law. Thanks to the Douglas County School District in Douglas County, Colorado, we now have something known as a daisy chain email, which is also an open meetings violation. And in Douglas County, what they did is the Board of Education had a series of one-on-one emails in a single email chain. So if you were to print out that email, you would see one-on-one emails, which technically would not be an open meetings violation, only 2 people. But what they did is they made a decision. So, and I'm going to, let's say Patrick emailed me and said, I think X should be fired. And then I emailed someone else on the board and said, I agree, X should be fired. And suddenly you had every member of the Board of Education, or most members of the Board of Education, a majority, saying the superintendent should be fired. There was never an open meeting. The court found that that was an open meetings violation because they made a decision by email without an open meeting. I don't know how much email communication you all have. I hope, frankly, none on BOA business. But if you do, number one, make sure it is not about evidence related to a quasi-judicial matter. And number two, it should always be one-on-one. Never more than 2 members of the BOA on any email chain where you are actually communicating amongst each other. Those communications should be had in an open meeting. Next slide. You are also authorized to have executive sessions. Patrick, I don't know, in my experience, I don't know that has there been an executive session of the BOA?
Not in my experience, no.
Mine either. So they are rare, but it could be that there is a legal issue that presents itself that you need legal advice on before a BOA meeting. If that were to happen, you are authorized to go into an executive session. There are very specific statutory requirements that we would adhere to. But again, since in the last, 7 years, 8 years or so, to my knowledge, the BOA has never needed an executive session. Next slide. I mentioned conflicts of interest. This is the statutory basis. And again, it is generally performing an act that impacts your economic interest, a family member's interest, or is perceived as doing so. And so again, it is in a community the size of Canyon, these kind of issues can sneak up on you. And so that's why I always say use the above the fold example in the daily record as your guide to whether or not you have a conflict of interest. Next slide. Lastly, so long as you all are acting within the scope of your authority, you are covered. You are covered by Canyon City's insurance policy. We have insurance with what's called the Colorado Intergovernmental Risk Sharing Agency, or CIRSA, and CIRSA will defend all governmental officials and the government itself. But as it relates to those governmental officials, they have to be acting within their scope. What are examples of acting outside of one's scope? Well, it's the things like violating the 3 issues related to quasi-judicial actions and not prejudging something, not having a conflict of interest, not communicating ex parte. Again, the idea when I spoke at the very beginning about, saying, hey, if you apply for a variance, I'll make sure you get it approved. That's the kind of thing that would be acting outside of the scope. But if you are following the guidelines that Patrick identified, that I've identified in this presentation, you are absolutely covered under the Colorado Governmental Immunity Act. The city's covered. There is no personal liability whatsoever. Questions?
Anybody have a question? Actually, I do. Would you mind covering, and I know it's either Patrick or yourself, this comes up from time to time when we look at a variance request and you look at the documents and you just can't get a good feel for what you're looking at as far as visiting the site.
It's a great question. In my opinion, as long as you disclose that you have visited the site, I don't have any concerns. Now, there's a difference between visiting the site and investigating. You cannot independently investigate. So, let's say that there's a new buyer for the site and you want to know a little bit about that buyer. Well, that is exactly what you can't do, because that is doing your own investigation. It also doesn't apply to the criteria. But driving by the site to get an idea as to what the evidence will show, if let's say one of the criteria is that the topography is somehow unique and there's only a small building envelope on a given lot. I'll be the first to admit that a picture may not do it justice. And so it is not, in my mind, outside of the scope to say that you visited the site so long as you disclose it on the record. Worst case, if that were to happen and someone objected, you would continue it so everyone could go out and visit the site. But in my view, that is just getting a better ability to observe what staff is trying to show you in the public hearing context. But it's a great question.
Thank you. Anybody else? Bob? No? Randy? You still with us, Randy?
I saw Randy, there he is.
I'm still here.
Okay. You have any questions?
No, sir. No,
Okay.
sir.
No one else in? Well, Mr. Hoffman, I sure appreciate that. That was very informative.
My pleasure.
And under the context that Corey was talking about your emails potentially being discoverable should the city be subject to judicial review or sued or something. This is why we have created for all of you the @canyoncity.org email, so that your personal email accounts are not subject to it. Whenever you get correspondence from me pertaining to official Board of Adjustment actions, that's what I will do. I will send it to your @canyoncity.org email account to avoid your personal email from being entangled that way. And if you're having trouble using it, get in touch with me. I can put you in touch with our IT staff, and they can walk you through whatever issues you need to get resolved to access it on your phone, your home computer, tablet, whatever.
Okay. Well, if there's nothing else, we don't have any announcements, so the meeting is adjourned. Thank you.
Thank you.
Have a good night.